Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Welcome to Inheritance Solutions for a Diverse Community with Richard Hall, founder of Bottom Line Lawyers. Richard combines extensive legal and real estate expertise to help clients with estate planning and to protect their family futures. I'm Matt Skye. Richard, thanks for joining us.
Thank you, Matt. Pleasure to be here.
Okay, let's jump in. So we're going to be discussing probate. So can you define probate, trust litigation, and trust administration for us?
Sure. Very different processes. I'm going to start with trust administration because that's the piece where you don't go to court. In trust administration, basically there's a instruction set that the trustor created, what they want to have happen with their possessions. And the job of the trustee is to follow that set of instructions. And that's called trust administration. And in that process, notices get published and assets get marshaled, an accounting gets created, and a distribution occurs. In a probate is what happens when an item is not taken care of in a trust. So that's a court process by definition. And you present a will or the absence of a will, which is called dying intestate, to the court. And the court appoints someone to act as a administrator of the estate, and generally they get full administrative powers to do anything they need to. Sometimes they need to post a bond for the value of the estate, but if there's agreement among the beneficiaries, they can all agree to waive a bond. And that probate process starts with a petition, then notice has to be published in a local newspaper, and once those things are accomplished, then the judge will review that and decide whether or not to issue letters testamentary, appointing someone as administrator of the estate, and decide what their powers are. In the petition, you can ask for specific kinds of powers if you happen to need them, but most of the time the general powers are sufficient for most administrators. And that process is similar to trust administration, except it all happens under the purview of the court. And so there is a process where notice goes out. There's a process where the assets get marshaled, then there's an accounting, and then there's a distribution that must get approved. So the accounting has to be approved by the court, and the distribution has to be approved by the court, and fees get paid. And fees are much more substantial in probate. They're dictated by statute what the amount of the fees will be, and those fees can be both for the attorney running the probate and for the person serving as the administrator. And the probate process usually includes what's called a probate referee if there's real estate involved in their estate, and the probate referee will make a valuation of the real estate and provide that to the court. So the court knows that the value that's being assessed by the administrator is in fact an accurate value. And that process can run 2 or maybe even 3 years. It was running long during the COVID times, and now I think we're back to more like 2 or so years. But there's also a shortage of time for hearing contested matters. And so right now, for instance, in Placer County, if you have something that needs to go to trial to resolve an issue in a probate, no trials have been set since January 1st of this year. And it doesn't look like they will be set for trial until sometime in 2025. So you can see the process can be prolonged substantially, and it's much easier for people to contest things inside of a probate than it is inside of a trust that has proper language. Then trust litigation is the third category you asked about, and trust litigation really deals with going to court to dispute some aspect of the trust. Now, most trusts, certainly the ones that I do, have what's called a no contest provision. And the no contest provision precludes most kinds of contests, but not all. So for instance, if you felt like the trustor was not mentally competent, not legally competent at the time they made their trust, then you can contest the trust on that basis, even if there is no contest provision. Or if you felt that somebody imposed undue effect on folks, then that undue influence is basis for contesting a trust. And I'm seeing a lot of undue influence cases these days, a lot where somebody graciously moves in to take care of mom or dad or aunt or uncle in their final days, and somehow it ends up that they get all of the assets because they persuaded the trustor that's what should happen. Usually that's as a result of undue influence. And so it's trust litigation where those things get resolved. A judge will try the facts in that case and decide, a winner and a loser. And trust litigation can be expensive. And time-consuming, another example of trust litigation is when the trust administrator or trustee is not doing their job. We've got that situation right now where the trustee was appointed, the person died 4 or 5 months ago, and they're just not doing anything. That's not acceptable. They have statutory duties under the code that they have to fulfill. And if they haven't, that's cause to get them removed as trustee and get someone else appointed. Sometimes, as in this case, we persuade the existing trustee that they're far better off resigning their position and letting someone else take over as trustee rather than have a court battle over whether they remain trustee, because there's not a lot of benefit to being the trustee, honestly. So that's the basic difference. Probate is always in court. Trust administration is never in court. Trust litigation is in court. Whenever you hear that phrase, in court, you can think dollars and time, because that's what it takes.
So when you get into probate proceedings, what are the primary goals and outcomes? And in which situations is probate typically required for estate settlement?
Any asset that isn't in a trust is going to go through some form of probate. Now, if you have a small estate, which is currently defined as $186,000 or $87,000 or less of assets that need to be probated, then that's going to go on a small estate affidavit. But some things, like if you have a checking account and it's got $10,000 in it, if you have a POD, pay on death, then that doesn't have to be probated. And the person who's named as the beneficiary of that on the pay on death statement simply walks into the financial institution. They say, here's a copy, certified copy of the will. Here's a certified copy of the death certificate. Here's a government ID that proves I'm that person. Give me the money. And they do. Pretty straightforward process. There's something similar for stocks. You can have what's called a transfer on death provision, and that's usually also naming a beneficiary. Sometimes we'll have a POD or a beneficiary statement that names the trust. And so that the money actually goes in the trust. And that's a much easier way of taking care of it, because if you've got a significant asset in an investment account and you want to divide it among 4 or 5 people, most financial institutions will not do that. They don't want that complexity. They just say, give me a name or two and we'll do that. But other than that, we're not interested in being your lawyer for this purpose. And so the simplest thing then is to name the trust as the beneficiary on the pay on death or transfer on death statement. And that money comes into the trust in the same way. The trustee goes in, here's the certified copy of the trust, here's the certified copy of the death certificate, here's government ID proving I'm that person who's appointed as a trustee, give me the money, and they do. So that's typically the way that happens.
And we touched on this, but can you lay out for us the key differences between trust litigation and probate proceedings? And what are the reasons something may lead to trust litigation?
Yeah. So probate must happen when you have no will, or if you have a will that has items in it that are not otherwise disposed of, like a pay on death that we just talked about. So it must go into a probate. Trust litigation only happens when there is a dispute over the trust administration. So it is actually the exception and not the rule. Things don't usually go to trust litigation. I'd say maybe 10% of the time. So as I say, probate must go to court. Trust litigation is only when there's a dispute about how the trust is being administered or what the contents of the trust are. And probate is a somewhat slower process, and by definition, because in a probate, you have to make sure that everyone gets notice of what, if they're a potential beneficiary, contingent beneficiary, or otherwise, they're entitled to notice of what's happening in the court before the court makes the decision. In trust litigation, you've already identified who the players are, so to speak, And when you file a petition for trust litigation, you're already giving them notice, so that can move a little bit faster.
So what does trust administration entail in contrast to trust litigation? And what are the key responsibilities of a trustee during the administration process?
So trust administration is, a multi-step process. Is give notice, marshal assets, prepare an accounting, distribute. Fundamentally, those are the 4 steps that have to happen. They sound simple and easy, but they can be very complicated. Notice is absolutely essential. Otherwise, you don't cut off claims that could come out 30 years from now. Marshaling the assets means finding everything and making sure that everything is accounted for. And I think I mentioned it as another example that you could find old stock certificates from 1930 that need to be chased down. And I actually had this situation, and stock certificates from 1930 were in paper. They are not in paper anymore. You get electronic records. And that stock had been split multiple times. And some of the companies that the stock had gone to had gone out of business. And so marshaling that asset was quite an ordeal to figure out how much it was really worth. And sometimes you have art objects, and art fluctuates a lot with the marketplace. So when the economy is strong, art values are up. And when the economy is weak, art values are down. That's one of the times when the trustee may exercise his or her discretion to defer the sale of that until it's a better time. And that's a legitimate thing to do. But that's another example of marshaling the assets. Or you may have a rental property that's subject to a lease, and that lease goes for another year or 2. So you may have to live with that rental property as is until the lease expires, or negotiate a buyout of the lease or something else so that that asset can be properly marshaled and added into the estate. Accounting is the final piece of that, or before distribution anyway. And accounting has a lot to do with valuation. And again, if you were trying to evaluate a piece of real estate in 2008 or 2009 that had been put in the trust in 2005, that would be a challenge, because in 2005 it was worth, $400,000. In 2008, it was worth about half that. So valuation is significant. And as I said with artwork, it values from time to time, depending upon economic conditions. So that accounting has to be presented and approved by everyone unless it's waived. And then there's the distribution itself. And the distribution needs to be approved. In the case of a probate, has to be approved by a judge. In the case of a trust, sometimes it's approved by a judge and sometimes it's not, depending on what's in that trust. So that's kind of the basics of those procedures.
Just changing course a little bit. How does the involvement of legal professionals differ between probate, trust litigation, and trust administration? And when should individuals seek legal counsel in these respective situations? I'm sure there's so many different scenarios.
Well, in trust administration, your attorney is really your coach. He's telling you, you're the trustee, you've got to do these things. Here's the best and most effective way to do that. In trust litigation, they are your representative. You're basically not involved. They've done the legal analysis. They've filed petitions to get the court to take action. And the trustee is involved in name only. The lawyer brings that action on behalf of the trustee. In probate, it's kind of a in between those two roles. That the attorney is the coach for the executor in the probate, the administrator in the probate, but the attorney also is the one who's going to file the petition and make the appearance on behalf of the executor or the administrator. The answer to the second part of your question is, when should they have it? Again, I'm always into full disclosure, very self-serving. They should always have it. There's even if you don't actually need an attorney for any of the process, I would say the starting place is consult with an attorney and have somebody tell you, oh, you don't need to use me. I've had several people come in and say, you got a small estate here. You can do this on your own. Fill out the small estate affidavit, submit it to the court, and you'll be done. Or you've got assets that are only assets you have are things that are being transferred through a pay on death or transfer on death. You don't need to do a probate for those. You don't need trust litigation. You don't need trust administration on any of those things. So if you go to an attorney who's going to be straight with you and tell you, you don't need to do this, that's the best bet. But always start with that so that you can find out what it is that you don't know.
I kind of like you say, you don't know what you don't know, right? I mean, it's better to prevent and at least understand whether or not there's value in probate versus just guessing and learning the hard way. So let's get into time frames. Can you break down for us the time and costs associated with probate, trust litigation, and trust administration?
Sure. So trust administration, assuming that there are no hitches in the giddy up, that is to say that there's no question about valuation or no restrictions on transfer, things like that, can usually be accomplished in 6 to 8 months. However, if someone challenges something or you need direction from the court, then you're getting into trust litigation, and that can be far more lengthy. I'll give you the most extreme example that I'm aware of. It was not my case, for which I'm grateful, but a rancher in the Northern California area left his entire estate and made all 10 of his children co-trustees. They argued and argued and argued, and it took over 10 years of litigation to resolve that trust. Now that's definitely at the far end of the bell curve. Doesn't happen that way very often. The midpoint of the bell curve is you're probably looking at 18 months or thereabouts, depending on the nature of the issue that's being litigated. And then probate, generally speaking, you're going to look at a process that is about 2 years. And that's because you have a lot of people involved. Besides the judge themselves, you also have a probate referee, you have different kind of appraisers that may be called upon. You have more rigorous process for administration, for accounting than you might have in a trust. No ability to waive the accounting very effectively if there are multiple beneficiaries. So it's probably the lengthiest of all the procedures and may or may not be the costliest. Trust litigation can get very expensive, which is why we do our best in creating an estate plan that prevents any kind of litigation. You can cut off the path towards litigation in several different ways, and that's what we attempt to do with our drafting technique.
What's your advice for preventing trust-related disputes or legal challenges in general, if possible, when possible?
Well, being as transparent as one can. Now, I will say that differs from my advice pre-death. I don't always recommend making the contents of your trust available to your beneficiaries. You all seen the whodunit movies where somebody left a fortune to somebody and suddenly they showed up dead because they found out about they're going to get money. But you can, far lesser problems, like just creating conflict between siblings, can occur when you differentiate who's getting what in a trust. And so I don't necessarily recommend that you do that. Also, since we're on that topic, I certainly don't recommend that you put a trust in your safe deposit box, because you can create a problem where somebody's got to go to court to get access to that box, but they can't go to court because they don't have access to the box to prove that they're entitled to access to the box. So not a good idea to do that. It is a good idea to have both an electronic copy and a physical copy. So in my practice, what we do is we scan the fully executed trust. We give the original trust to our client and provide them with a thumb drive with a scanned copy of it as well. And I retain a scanned copy of it so that if it gets lost or stolen or burned up in a fire, that they can simply recreate that easily enough.
So when navigating probate, trust litigation, trust administration processes, can you lay out for us some steps people should take to ensure a smooth and successful outcome for all parties involved? Or maybe like we talked about, that successful outcome where everyone's a little unhappy, but at least you got somewhere?
That's right. Well, and I will say the law in California has changed. The definition of who's a potential beneficiary has expanded, so that many people that aren't explicitly named in a trust or a will still need to be given notice because they potentially could have a claim. And really the issue is making sure that they know that there's an action underway for a trust or for a will, so that if there is an issue, they can raise that issue early and resolve it early by negotiation and mutual agreement. That's going to be true whether it's a trust administration, a probate, and God forbid if you get into trust litigation. Always communication, transparency are the two key words there, and that's what's going to help you get off. I got to come back full circle and disclose being self-serving. Start with an attorney, even if you don't stay with the attorney, even if you decide you're going to tackle it on your own. get somebody who knows what they're doing about that process, whether it is a probate process or trust administration process. Make sure that you know and they know what they're doing, and that you understand what it is that they need to do. I've had folks where, I said, yeah, they said, can you do this? I said, yeah, I can do that. But by the time we're done, you may have spent $20,000 in legal fees. So I want you to, we may get it done much easier than that, but I can't guarantee it. Litigation is the great unknown, and your risk in litigation is significant, which is why I always encourage people to go to some form of alternative dispute resolution rather than going to outright litigation, trial or otherwise.
Yeah, interesting considerations for sure. So just as we wrap up, we covered a lot of different areas. Any single takeaway you hope people walk away with, if only one?
The one thing that I'm trying to encourage a lot of is, if you know people who have assets and that don't have a trust to your knowledge, encourage them to pursue that. If you're a potential beneficiary, whether you're a son or a daughter or a niece or a nephew or whatever, encourage your potential benefactor to take care of that, because it's absolutely inures to your benefit. The process is simpler, less expensive, and far more pleasant if there's a good estate plan in place than if there isn't. And we always think, well, that's their private business. It is, right up until the time you're now in charge of having to take care of these issues. And that typically happens with children and their parents. And the children don't have the documents in place to be able to do the things that are necessary. And as between parent and child, frequently there's a reluctance to talk about financial matters. But it really needs to happen to make sure that they're prepared, and not just the financial matters, but also the end of life issues. If you lapse into a coma, what do you want us to do? What's your standard for wanting to be kept alive? Do you want to be kept alive in perpetuity no matter what? Or do you want them to pull the plug once you can't have brain function? Those are questions that need to be answered in advance. And I would encourage the potential beneficiaries or agents to have that discussion so that they have clarity and that they save themselves time and money when the inevitable happens for all of us.
Yeah, these are definitely important discussions, both from a financial standpoint, but also just a life standpoint, a quality of life standpoint for the living and for when someone passes on. Everyone, thank you so much for listening. This has been Inheritance Solutions for a Diverse Community. For more information, you can find Richard Hall on social media and visit bottomlinelawyers.com. Richard, again, thank you so much for your time.
Thank you, Matt. My pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.